Members, the Housing Committee on the Companies and Limited Partnerships Amendment Bill. We move to debate on Part 1. This is clauses 3 to 43 and schedules 1 to 2. The question is that Part 1 stand part. The Honourable David Parker.
Mr Chairman, I want to discuss with the Minister and the Chair the provisions of Clause 4 of the bill, which insert Clause 138A into the bill, which is a varied form of the offences for serious breaches of directors' duties, for which we have a supplementary order paper. Mr Speaker, before doing so, can I explain why, in my view, these clauses are very important? Mr Speaker, we have limited partnership and companies so as to limit the liability of investors essentially to the amount that they invest. Otherwise, were it not for those limitations and we had either partnerships or other forms of joint venture, the participants in those ventures put the whole of their legal entity's wealth at risk in respect of what can be a relatively small investment, and accordingly, without these limited liability vehicles like companies and limited partnerships, capitalism doesn't work well because people aren't willing to invest, because they take too much risk in respect of a relatively small this venture in respect of their other assets, and therefore they don't put them at risk. And money doesn't go around in the economy, and therefore the economy doesn't prosper as well. And that's essentially why we have limited liability companies. That and the fact that that sort of an outcome can be unfair to the people involved, and that they can suffer a unfair consequence in respect of their personal liability for an unincorporated venture. Now, when people give over money through a corporate venture or as an investor in a share or in a limited partnership, or they lend money or provide services to one of those entities, they put their money at risk, and if the directors of the company or those that are in charge of a limited partnership act improperly, they can cause a loss either to creditors or to the investors. And so again, there has to be a line drawn as to what their liability should be, and when liability should arise if those directors of these entities breach their duties in a way that causes a loss to other people. Now again, these lines are quite hard to draw. If we get too tough with these lines, we actually don't get good people willing to act as directors. And that's been one of my criticisms of recent securities law, is that we've actually gone too far in respect of directors' duties, in respect of prospectus risk when they raise money from the public. The effect of this has been that the best directors who have already succeeded, who you want to be bringing their efforts to bear for the good of the economy and to minimise risk for people who would be investing in these new vehicles, they're not willing to do it because of prospectus risk, and therefore risks actually increased because those good directors aren't there, and that's a worse outcome than having a lower standard of care in respect of prospectus risk for better directors, because those better directors will do a better job. Now, my concern with this provision is it's not in respect of civil liability, it's creating criminal liability for directors in some instances. And I have some difficulty with the fact that the Select Committee was in the position that actually had to report back to the House saying that they thought that these provisions went too far, but they didn't know really what the answer was. Now, that presumably was because there were submissions that were received by the Select Committee that the line wasn't being drawn in the right place, but either the government or the officials, who are, it's one and the same, weren't in a position to advise what the proper position was. And so they reported back to the House saying that they thought that some of the existing conduct by directors that's not currently subject to criminal sanctions is sufficiently blameworthy to warrant criminal punishment, but they also considered that the new provisions in the bill would allow in certain circumstances conduct that's already subject to criminal sanctions to be prosecuted more directly. However, we're also aware the bill would be perceived by directors and their advisers to criminalise legitimate business risk-taking behaviour, i.e. they said it was going too far. It was going to criminalise some behaviour that would then that shouldn't have been criminalised, and the effect of this, and they said it explicitly, would be that it would have discouraged entrepreneurial behaviour that we actually need in our country in order to prosper. So, Mr. Chairman,
Honourable David Parker.
Thank you, Mr. Chairman. So they flicked it back to the House and they said, "Oh look, although we recommend no changes other than mining drafting provisions, we support further consideration of the drafting of these new offences to ensure that the provisions are expressed in a way that provides clear direction, clear guidance to directors and doesn't have a chilling effect on legitimate business risk-taking." So it gets back to this House with the problem that was actually at the centre of the first substantive provision of this bill actually still not having been fixed. And then we have a supplementary order paper that we're debating today that fundamentally changes the wording of the Act in a way that hasn't been considered at Select Committee. And it does this by changing the wording of one of the two arms of criminal liability and deleting the second. So it completely ditches the second, which was that every director of a company who acts or omits to act in breach of the duty provided in section 135, which was reckless trading, commits an offence if they know that conduct will result in serious loss to the company's creditors. Now that's gone. That's been ditched completely. And I'm not sure whether that's right or not. I suspect it is right, actually, but I'm surprised that if that was so obviously right, that it wasn't ditched at Select Committee and that the bill went to Select Committee with it in the first place. I'm further surprised that if it's being ditched now, that the government and the officials couldn't give that advice to the Select Committee when it was there recently. In respect of the first arm of these prosecutions, they've changed it from every director of the company who acts or omits to act in breach of section 131, which is the duty of the directors to act in good faith in the best interest of the company, commits a serious offence if he or she knows that conduct is seriously detrimental to the interests of the company. And they've softened that substantially so that it now reads, a director of the company commits an offence if the director exercises powers or performs duty as a director of the company in bad faith towards the company and believing that the conduct is not in the best interest of the company and knowing that the conduct will cause serious loss to the company. Now, again, I can see why the first test was too loose. I really think that was how long is a piece of string? Seriously detrimental to the interests of the company. That's pretty loose language. But I am questioning, Mr. Chairman, why it is that you prove bad faith. So you've proven bad faith. They didn't intend good things. They intended to act badly, believing that it wasn't in the best interest of the company. Seems pretty serious there. So this is deliberately bad faith conduct. And then they say you still have to prove in addition to that they knew that the conduct would cause serious loss to the company. Now, I'm not convinced, having toughened up 1A, that you actually need B. Why should you, in that situation, someone's acted in bad faith, deliberately, believing, you've had to prove that they believed that their conduct wasn't in the best interest of the company, and then you've still got to prove that it's serious loss. Why should you have to prove serious loss? I would have thought, in that case, if it wasn't serious loss, the penalty's not going to be very high. But the conduct's still been highly improper. If you knew that you were acting in bad faith, you do it deliberate, believing that it wasn't in the interest of the company. I would have thought the criminal law should have a look at that. And if it isn't serious loss, then if it wasn't very serious, no prosecution's going to be brought. We've got prosecutorial guidelines and people exercise their discretion. But if it is, why do you have to prove serious loss? So my question for the Minister is, do we, at this stage, have confidence to know that we've got it right? Because I'm not having much confidence in this process until now, given the history as I understand it from the documents. Now, I wasn't on the Select Committee, And I do know a bit about this stuff, but I haven't had the benefit of submissions. I am surprised that at committee stage we're actually effectively, fundamentally changing these clauses as they went to select committee and as they came back to select committee. And I'd ask the Minister to address why that was necessary, and secondly, to address why it is, once you prove bad faith and knowledge that the conduct wasn't in the best interest of the country, why you have to prove serious loss rather than just letting that go to the criminal justice system. And if it's not a serious loss, well, obviously the penalty's not going to be very high.
Issues, but otherwise I'll take a call, Mr. Chair.
I'll call Dr. David Clark.
Thank you, Mr. Chair. Well, I do look forward to hearing those questions answered, and the Minister was halfway to his feet. I was quite happy.